SJC-11402, Father Joseph Randall and another v. Marion Haddad and others.
Thank you, Dad.
Good morning, Mr. Chief Justice and Associate Justices of the Court. I request 3 minutes for rebuttal time. May it please the Court, my name is Michael Walsh, and I represent the plaintiff's appellants, Father Joseph Randall and St. Nectarios Monastery. The essential facts of this case are established. The defendant, Marion Haddad, took funds belonging to the plaintiffs, and on March 3rd, 2006, after dissipating much of these funds on herself, she transferred $40,000 to her personal state retirement account. At this time, Haddad was already being sued for the recovery of those funds by the plaintiffs in Middlesex Superior Court. And the money came from the sale of real estate belonging to the plaintiffs. On March 2nd, 2006, the day before she deposited these funds.
Well, there's no disagreement about the facts, but does the statute allow us to reach that $40,000?
I would argue that it does, Your Honor, because
Where's the language in the statute that allows us to do that?
it says that the rights of an employee to a pension, annuity, or retirement funds are not attachable. The rights, that question leads us to law and equity issues. The law is title issues. Did she have title to the funds? And equity equals clean hands or unjust enrichment issues. I would say both of those argue that this court can reach those funds, as well as the Uniform Fraudulent Transfers Act.
I didn't mean to interrupt you. Just you really do focus on the fact that she doesn't have title, which sounds to me like conversion, right?
Yes.
And there is a principle in the law, wouldn't you agree, that if you don't have title, when you give it to someone else, it's not yours. You don't seem to focus on that particular aspect of your claim once the funds, which you can trace, as you argue, are actually in the account.
I'm arguing on the brief of another, and perhaps if I had originated the brief, I would have stressed that more. I've studied the case this court did in Bevilacqua versus Rodriguez. I think the same principle applies, is that U.S. Bank gave a bad deed to Bevilacqua, who tried to quiet title, and this court said, Mr. Bevilacqua, you don't have title because U.S. Bank didn't have title. I would say the same thing with the retirement board.
Are you looking for a narrow exception, or are you suggesting that any time a state employee or a governmental employee owes money, that the amount that person has in a retirement account can be reached for purposes of a debt, even a legitimate debt?
That's a very narrow exception we're asking for, and it's actually a very narrow role that the state has in this.
And what are the parameters of the narrowness?
Illegitimate funds, money that's stolen, embezzled, converted, drug money, something would amount to money laundering. Those kind of funds should be reachable.
Can I just follow up on that? Because I see a further narrowing. So it's not a debt. You're not looking just to follow, you owe money, so let's go get the money. That's now, we can see a pot of that money in the retirement fund. Are you arguing that any time there's a theft, we shouldn't aid this thief? Or are you arguing, as are the facts of this case, that any time that there is a theft, a conversion, here there was adjudicated taking of money, and it's recognized that it was, given the timing, that those funds can be traced to the $40,000 that ended up in the account? Could it be so narrow as to only include those kinds of converted, that is, traceable funds with knowledge, such that it's not her funds, you can recognize them?
I would agree that it's very narrow. It pertains to the exact property that you can trace. It's almost like she took an automobile and parked it in a state garage, and they're saying the real owner of that car can't have it back. Only the person that parked it can get it back. And so, yes, it's that.
Well, it's not quite like that. I mean, there's a very clear statutory prohibition on reaching these funds.
Yes.
So it's not exactly like parking your car in a parking lot.
Well, it does say the rights of the employee to those funds. The rights are not attachable. It doesn't say the funds themselves.
Can the employee take the money out?
I'm not sure what the rules are. I've not been a state
I mean,
employee.
I guess what I'm getting at, why isn't contempt the right approach here?
Civil
Person goes to
contempt.
jail and civil contempt until they take the money out.
I've looked at that issue. I didn't have the case below, so I might have sought contempt. These are monks. They're a monastery. I think they are trying
No, I'm not
to
talking
be-
about putting the monk in jail. I mean,
No. They don't want to be as aggressive. They don't want to put this woman in jail. They knew her. They trusted her. She was a fiduciary, which she violated her fiduciary duty. So
Okay, so if they weren't monks, is contempt, why isn't contempt the right approach, the adequate remedy
I
here?
think it might be a good remedy. I may have chosen to do that below if I were involved in the case. There's also Rule 70, the Rules of Civil Procedures, the appointing of a receiver. That could avoid the issue of general attachments or trustee process against the retirement funds.
Well, in this case, wasn't there a judicial order that she not take this money and use it in any way?
I believe Judge Connolly issued that order that she was supposed to hold it in escrow, and she didn't. The day after he issued that order, she deposited it in her
So that would bring us back to contempt again.
retirement, yes.
One other point on fact, and that is what really gave rise to this action. I have Mr. Hession's affidavit at 40 of the record. He says that she actually has asked for that $40,000 back, and that was really what prompted this. So it's not just that she put it in, but she was apparently able to seek it back, and the retirement fund was about to release a check to her.
I don't know if they were about to, but she is old enough to get a retirement.
Just she could take the 40 or a 40,000, which is the
That's one
request.
suggestion the Attorney General has, is that we should wait, and as each
Right.
retirement payout is made, we should then do some kind of an action against her, which would exhaust her, the resources of my clients to try to attach every single payment that's made to her, if it's made on periodic payments.
How old is she?
I think she's in her 70s, well into her 70s. I'm not positive about that.
Is there an ERISA issue here?
Isn't that a federal matter?
Yeah.
She did go to bankruptcy court, and she sought to be discharged. However, the bankruptcy judge accepted this asset from her bankruptcy estate and described her interest as only a contingent interest, which I would contingent on Your Honor's decision as to whether it can be taken out.
Apart from your argument about 3119, which is what we've been discussing, what about the statute that basically you can't have trustee process against the retirement board?
Right. Well, my argument there is one of equity. There's not always a tension, but there's often a tension between law and equity. The Attorney General argues that this is a statute that cannot be moved at all. It has been moved in the past. The two cases the Attorney General cites are different. They both involve money that belonged to the retirees, the former state employees. This is unique. This is a matter of first impression where someone has taken other people's funds and put them in her own retirement account. And I would say Murphy's Law may not be primary law, but it's a good source. It will probably happen again. So it's a time to perhaps plug up this hole where illegitimate funds can be preserved for the benefit of the wrongdoer, yet withheld from the people who have been the victims. It's a reversal of the role of the courts, I would see. We want to vindicate the rights of people who have had property taken from them, and punish the wrongdoer, at least restore the funds to the people who own them.
Now,
Well,
is,
I mean, go ahead.
is there any consequence in your eyes to the fact that under a Uniform Fraudulent Transfer Act, a person includes government entities and would therefore include the retirement fund?
I do. The definition sections does state that the person, for the purposes of Chapter 109A, includes government subdivisions, and agencies. It's not inexorable, but it certainly is persuasive that government is not excluded from Fraudulent Transfer Act.
And what leads from that?
Pardon me?
What leads from that?
Well, that's where you'd have to narrow this, because in a fraudulent transfer, you are perhaps looking at funds of a different kind being attached. Someone takes money that they owed they owed someone money, just as in a bankruptcy situation, and they took it, instead of paying their creditor, and they deposited in their retirement fund. That sounds more like a typical reach and apply action, which Chapter 3219 seems to argue against. Somewhat dissimilar to our circumstances, where we have actual funds that were taken from my client. It's not funds of a different kind. It's not making this pay for that. It's the very thing that was taken that's in the retirement board, so. But, you know, this case does fit much of the description in the Uniform Transfers Act, Fraudulent Transfers Act. It was done to defraud with the intent to defraud and deprive and to conceal funds. The remedies there are quite expansive. It talks about the appointment of a receiver, the issuing of attachment. If someone has an execution, they can levy upon the funds. My clients did obtain a judgment for a little over $160,000, so they have an execution, but we are stopped by the courts below.
With respect to the Fraudulent Transfer Act and remedies, could you do these various statutes prohibit you from being able to, let's assume government entity, I mean, you get there. Can you get at these funds in the retirement board? I understand what you're saying about it's really these funds, it's not a debt. I get that, but put that aside.
Yep.
Are there roadblocks to your being able to do that under the Fraudulent Transfer Act?
I don't see any there. I see, the roadblock I see is in Chapter 32, Section 19, which says you can't attach funds of the rights of a retiree to the money.
But then your argument is, but she doesn't have rights in something that isn't hers.
Right.
Okay.
What about levying on an execution at such time as she may seek to withdraw the funds? Is there any statute that prevents that from happening?
No, once funds are in the possession of the retiree,
No, one step before
Oh.
their return to her.
I would think it's an either-or situation. It's either night or day. It's either the funds are in the control of the retirement board and they're according to the Attorney General, not attachable under any circumstances, or they are in the hands of of Marion Haddad.
But does attachable include post-judgment, a levy on execution?
I would like to think that you could execute on them. I don't have any hard and fast law on that. Again, this is a case of first impression, and it's Your Honor's job to try to work this out, because we obviously have an unjust end with a statute that seems to be unyielding. But again, I point to the issue of the rights of a retiree to the pension.
All right, counsel, well, because you've reserved 3 minutes, I'll stop you here.
Thank you.
And we'll hear from your brother colleague.
Thank you, Your Honor. This was certainly an unfortunate situation for the plaintiffs, but they need to enforce their judgment against Ms. Haddad in a way that complies with the law. Equity follows the law. The plaintiff's trustee process claim that they're attempting to bring against her retirement account faces two insurmountable hurdles. First, there's no statute that waives the Commonwealth's sovereign immunity from trustee process claims. And as the recently enacted statute we noted in our Rule 16L letter points out, the legislature has recently reaffirmed that it does not want state resources expended on compulsory trustee process orders. And second, and even more specific to this case.
Of course, the expenditure of state monies on trustee process is really minimal, isn't it? I mean, the only thing that a trustee has to do is say, yes, the trustee's answer is either no, I don't have the person's money, or yes, I do have the person's money, and then the amount. That's it. It's not a huge expenditure.
The legislature has made a determination that it's more of an expenditure than it wants to make. You're saying in one case that might be the case, but we get frequent requests to garnish wages, for example, to attach people's pages. We're frequently in court making motions that you can't bring trustee process orders. So I don't know that any one would be a huge volume, although if it was on an ongoing basis where you had to each week administer someone's payment.
What about levy on execution? Post-judgment, you have the execution. It's not really an attachment. It's a little bit better. It's the gold standard.
Well, the statute says that the retirement fund shall not be attached or taken upon execution or other process.
Okay.
This court in Utley said that unambiguously and comprehensively prohibits attachment. And the court also said in Utley that only the legislature and not the courts can write exceptions into Chapter 32, Section 19.
So the plaintiffs here could go to the legislature and try to get special legislation just for their case.
I don't know what Ms. Haddad would say in response to that, but if there was a statute that required us to do something, then we would comply with that statute.
Well, if you added an exception, like the second paragraph about nothing in this section shall prevent, et cetera, if they added it in a special act, nothing in the statute shall prevent getting Ms. Haddad, the money that Ms. Haddad unlawfully put in there.
And the legislature does have some exceptions in other retirement statutes that don't apply to the state that we've cited in our brief. I think Chapter 246, Section 28 has a 5-year look back before a judgment or a bankruptcy for contributions that exceed 7% of the annual income. There's another statute that we cited in there that's included in our addendum that also, if it's restitution for a crime, you can pay it back. So the legislature is capable of writing these exceptions. It has not written one with respect to 32, Section 19, and I suspect, although I do not know, that is because the private retirement boards are being treated as trustees by the statute, and the Commonwealth cannot be sued as a trustee, so you'd have to be creating an exception
But
too.
even the exceptions, well, except for the criminal restitution one, and I understand your concern. You don't want to always be going into court and doing something with these funds and then maybe litigating or not, whatever the issue is. But do you accept that this is potentially a really narrow exception, such as would be the case if you were subject to a suit for conversion? Because under the law, let's say, if you accept that this is the $40,000 that she misappropriated, a judgment of misappropriation has entered, and took those funds as traced through the record and put them in this account. They're not her retirement funds. She never took title. So under those narrow circumstances, if you were subject to suit, you wouldn't hold title either, and you'd be held liable as a converter if you didn't return them to the rightful owner. Why couldn't you, in those circumstances, just take the position that this retirement fund is about the funds that belong to the retiree, to the member? And in this case, they don't.
At the time Ms. Haddad presented the check to the Commonwealth, it's a bank check written with her name and social security number on it, deposited, and then several years later the plaintiffs have come to the retirement board and say this was in fact not her money.
I understand.
Money is fungible, Your Honor.
It is fungible except under the law of conversion when you have knowledge coupled with ability to trace. I know it's not a horse. You can see the horse. But in terms of money, there is the extra requirement. So yes, you wouldn't be called upon to establish that it's not. They would be called upon to prove, as this record could arguably show, here are funds that don't belong to her, that belong to me. And now that you know, you're going to be liable for conversion because now that you know and you can see this, you've got to give it back. It's not your money and it wasn't hers.
The pension statute or the retirement statute has specific scenarios where someone can forfeit a pension or forfeit contributions. That is not, they all involve criminal convictions or misappropriation of funds of the government unit. So the retirement board does not believe that for a simple
Section 15,
conversion
right.
that it can take her contributions and give it back. It would
Her
clearly violate this.
contributions. Right.
Let me ask you this. Knowing the facts, put this aside, was she entitled to buy back with these unlawful funds? So she's going to get a higher retirement out of this?
I think Your Honor is looking at two separate things with whether she should be entitled to
I know
retirement or
that.
whether
I am.
contempt
I'm asking
or
you that question.
whether contempt or civil or criminal contempt would be the appropriate remedy against her.
I want to know what
enforce
the
her
government
with-
is going to do. Is the government going to give her more money because she's got these illegal funds in there and she bought it back?
Under the statute, that's what we understand that we're required to do. And then she can use that to pay back the plaintiff if, pursuant to a court order. And I agree that is, it seems like an unfair
Over a very
result, but there's
long
no,
period of time if she lives that long, right?
say that again?
I mean, this is on a monthly basis. They can, if they can find her.
This is not in the record, but she did file for retirement in October 2008. At the direction of the Superior Court, we haven't been paying her, but my understanding, and this is not a final calculation, that it's approximately $60,000 that she'd be owed currently. And we have told the plaintiffs, when it was a lower amount earlier in the case, previous counsel, that we have a large amount there and there would be a large lump sum that they could collect, and that would be a good way to do it.
I appreciate that, and I suppose everybody probably has some sympathy for these circumstances, but I'm looking at the broader principle. I mean, she could, I'm looking at the principle that you're seeming to want to support, that money that has been misappropriated, identified as not belonging to the person who happens to have started a retirement fund some years before, can actually harbor those funds in an account, and once you know about it, the government will take the position there's nothing they can do. That's the principle that concerns me.
There's no indication in the statute that this is a type of meritorious claim by a plaintiff that would be different from the other types of meritorious claims that would otherwise be satisfied against a retirement account.
I see many differences. I see many differences, basically focused on the concern that you have, a legitimate concern, that there be too many people who are creditors who want to reach and apply money that they'd love to have, and they can't find another pot. I get that. This I see as different.
Would you agree with me that, given our facts, where a judge ordered her not to do this, and she did it the very next day, that although your position may be legal, it's not fair? Would you agree with that?
I don't exactly. I agree that it's unfortunate for the plaintiffs that they have to pursue either a civil or criminal contempt action or wait for her to get the money. The legislature has determined, for whatever reason, that retirement accounts are going to be protected. So while it may appear to operate in an unfair manner to the plaintiff, that was what the legislature determined would be fair, is that you cannot attach retirement accounts.
What consequence do you give to the fact that the legislature chose to include government or government subdivision or agency within the meaning of person under the UFTA?
The UFTA, if you look at the remedies section, it refers back to the trustee process statute, which still follows the general person's definition in Chapter 4, which does not include the Commonwealth. So it does not waive the Commonwealth's sovereign immunity from trustee process so much as incorporate it by reference. So whether she has a...
I'm sorry, I lost you. I mean, it speaks of, in terms of its remedy sec, do you agree that the government can be a transferee because it's a person under the UFTA?
This court hasn't addressed that, and...
Yeah, what is your view? I mean,
New Jersey
if the retirement agency is a government or government agency, you agree with that?
Yes.
And transferees would include persons, correct?
Transferees would include persons, yes.
And so therefore, the retirement agency can be a transfer or is a transferee under UFTA.
But the remedies section, Your Honor, Section
8.
8A2 says the creditor's remedies, when they go to execute the remedy, they use the existing trustee process statute.
Okay.
So
why does that not say that the legislature has recognized that a government agency may not be a safe haven for fraudulent transfers, and that the remedies under Section 8 apply to fraudulent transfers even when it is held, even when the transferee is a government?
I read Section 8A2 to incorporate the existing sovereign immunity from trustee process suits that's in Chapter 246, Section 1.
And what language are you focusing on?
It permits a creditor to obtain a detachment or other provisional remedy against the asset transferred or other property of the transferee in accordance with the applicable procedure set forth in Chapter 214 for actions to reach and apply, Chapter 223 for attachments, and Chapter 246 for trustee process in accordance with applicable rules of civil procedure. So if you could sue the Commonwealth for trustee process, then that would be a viable remedy against the Commonwealth. But because you can't, that remedy is only available against people for whom you could get a trustee process attachment.
But there's nothing in those statutes which say that you can't do trustee process against the government. That's a common law understanding and the application, perhaps, of the Tort Claims Act.
Your Honor, the definition of person under Chapter 246, Section 1 is the general definition of person, which does not include the Commonwealth. And numerous interpretations of this court say that that does not include the
Right,
Commonwealth.
but but we also say that when there's something that is specific, that when the legislature intends something specifically, it overrides a more general application.
And if that's true, Your Honor, then we still run into the same more specific statute with respect to the retirement statute, that even if you could get fraudulent transfers generally, you specifically couldn't get them with respect to the retirement statute.
I understand that position, but why is it not true that the UFTA provides for the declaration that a transfer is voidable at the time of transfer, and therefore would this not be a fraudulent transfer which may be declared to be void?
They don't have, the remedy available is under the trustee process statute that does not incorporate the Commonwealth.
Okay, but try my question. Now, do you agree that under the Fraudulent Transfer Act, this fraudulent transfer could be declared void under Section 9?
It could be declared void.
And if it is declared void, is it then, does that money then become part of the retirement funds if the transfer is void at the time of the transfer?
But the way you would have to go to actually get that would be to attach the retirement fund, the money in the retirement account. That's how you would execute it. It would be the end result would still be that the retirement funds would be taken upon attachment,
Right,
execution.
okay,
of
so
the process that's
basically,
prohibited by the statute.
what you're resting on is the view that the person as defined with regard to trustee process does not include a government. So that's basically what it comes down to as far
Going
as
to be
your argument.
construed narrowly with respect to the government, just as the New Jersey case that we cited construed it narrowly despite what appeared to be language that might incorporate it. When it cross-referenced another statute or where there was another statute that also applied, New Jersey applied the more broad, the longer statute of limitations for the state agency to bring a claim. In our case, similarly, you're talking about a general, the Chapter 246, Section 1 still doesn't waive the Commonwealth sovereign immunity, so you still run into the same problem.
In the context of a divorce case, am I correct that a probate court judge has the authority to apportion a state employee's pension between spouses as part of a distribution of the marital estate?
I believe that's correct, Your Honor, yes.
Is that based on a statute?
That is based on, within Section 32, Chapter 32, Section 19, is that what you're asking?
There's specific provision for that.
Specific provision for that, yes,
didn't
and for
this
child
court-
support orders.
But didn't this court, and I'm not going to remember the name of the case, but didn't this court interpret the statute as covering what Justice Fian is talking about before the statute was amended to do so?
No, well, interpreted as not including it, then the legislature went and enacted a statute that created the equitable exception that the plaintiff was arguing for in Utley. The court said in Utley, only the legislature can make these exceptions. The legislature went and made the exceptions.
Later than that, it was something that.
It was the
I thought-
Glassman case I think you're referring to.
Which one?
The Glassman case? Glassman versus Glassman was the New Jersey case you're referring to?
No, it's a Massachusetts case with an M. And it was in interpreting it after that amendment, but to something slightly different. Okay, never mind.
Well, counsel, you're going to have to wrap it up now.
All right, thank you, Your Honor. Again, this is an unfortunate situation, but we're constrained by the law. Equity follows the law.
Thank you. Yes, Mr. Walsh.
Just briefly, Your Honors, I would say my brother narrowed the remedies of Chapter 109A a little bit too narrow because one provision there in Section 8.3.2, two I's, that it says there's any other relief the circumstances may require. It's a very broad opening for the fashioning of equitable remedies under the Uniform Fraudulent Transfers Act.
Of course, one of the problems, though, is the exceptions that the legislature has carved out were carved out in Chapter 32, weren't they?
Correct.
And there is no exception carved out in Chapter 32 for this kind of remedy.
No, there isn't. Now, my brother argues that this court should be wary of assuming that the legislature did not contemplate this circumstance when it fashioned Section 19, and I find that preposterous, that the legislature could actually consider that fraudulent, stolen, converted funds would be deposited in the retirement board accounts and be preserved for the benefit of the wrongdoer and withheld from the victim of that wrongdoing. So there should be a presumption that the legislature only intended to protect legitimate funds, the actual earnings of the retirement.
Well, and the legislature may have also intended that the retirement fund not be battered around by litigation on whether or not these funds were legitimate or not legitimate, or how they were obtained or where they came from, and protect the retirement fund from that kind of, because the retirement fund covers hundreds of thousands of people.
Well, you have a case here where you have a judgment. You have a court that decided it. The matter's settled that these funds belong to my client. You have a Superior Court judge that prohibited the transfer, and it was done. So it's as open and shut on that issue as to whose funds these are, and maybe the exception has to be very narrow.
Yeah, it is. Put her in jail for civil contempt until she pays the money. It's
I know. What she did, it comprises elements of several crimes, I think, but that's a discretion of prosecutors and district attorneys, not plaintiffs' attorneys.
Is there anything in the statutes that would prohibit an injunction? I should have asked this of your brother, but that would prohibit an injunction that basically said, before you send this pot of whatever money you have that you've been withholding to Ms. Haddad, you need to give notice to your client?
I don't know if there's anything that prohibits that. I would think an appointment of a receiver would be precisely what would be a good remedy, is that if money is to be dispersed, the receiver is given notice and the opportunity to hold his hand out before that money gets in her pocket.
I mean, a receiver for Mrs. Haddad.
For the plaintiffs.
Yeah, for the plaintiffs, in the litigation.
We're the rightful owners of that money.
Right, but if she were 40 years old, you may have to wait 30 years for that.
But she isn't.
Yeah, I don't know how old she is. I think she's pretty aged, but,
Well, counsel, your time is up.
Your Honor, thank you for hearing me.